everyone, and welcome to Thompson Hine's Coffee Chat webinar series. My name is Agnes Kolbeck. I am an associate in the firm's Employee Benefits Practice Group. Thank you for joining us today for today's session, part of our ongoing Coffee Chat series designed to provide concise, practical discussions on timely topics impacting the financial services industry. Today's program is entitled 401k Investment Revolution, DOL Alternative Assets Proposed Rule. As the 401k landscape continues to evolve, the U.S. Department of Labor's proposed rule on alternative assets signals a potential shift in how plan fiduciaries, investment advisors, and investment managers approach investment lineups. Today, we will examine the proposed rule within the broader context of the ongoing 401k investment revolution, and we will break down key elements of the proposal and provide practical guidance on what it means for the future of retirement plan investing. I'm super excited to introduce my colleague, Brian Gage, Senior Counsel in the Employee Benefits Practice, who will be joining me for today's chat. Brian brings more than 30 years of experience advising on pension and fiduciary issues under ERISA. His work includes reviewing ERISA investment issues across a wide range of pension plan investments, including private equity funds, collective investment trusts, 401k annuity distribution products, investment management agreements, and OCIO arrangements. During today's program, we encourage you to participate by submitting any questions through the Q&A box at any time. We will address as many as we can during the session and follow up afterward on any that we're not able to cover. You should also see links on your console screen to register for upcoming coffee chat sessions, and we encourage you to explore those as well. Finally, please note that this discussion is intended for the general information of individuals and organizations on matters of current interest. This is not intended to be legal advice or reflect the view. This just reflects the view of the presenters, and participants should not act on the information presented without seeking professional counsel. All right, so with that, let's get started. Brian, let's just talk a little bit about alternative assets in the context of 401k plans. Is it new? For retirement plans generally, is it new to see alternative assets in investments?
No, actually, well, I'll break it in two parts. No, in a sense of private equity has been in it in defined benefit plans for a long time. Actually, I've really started focusing 15 years ago on basically trying to build this investment practice that I have, basically by reviewing a private equity fund for a pension plan. And unfortunately, I spotted an error in whether it held plan assets or not, and the client loved it and has continued to give me a lot of work. And so, but it's also, what's important is that in ERISA, there's no requirement as far as what kind of assets that you can invest in. And it's also clear that was a real break from state laws at the time, because state laws often had you couldn't invest in this or you couldn't invest in that, or you had to have a certain conservative. So if you look at defined benefit plans, they've always had private equity. They've had, I did work on foreign exchange agreements, derivatives. Those are all things that are in pension plans. They own real estate. It was very common for multi-employer plans to invest in resorts and construction, buildings and downtowns. And so the whole spiel, I'm looking over here, real estate, commodities, yes, that's clearly in it. Infrastructure investments, those are in it. Really the two things that, at least in the defined benefit context, obviously cryptocurrency and all of that is very new. So that hasn't been around for 20, 30 or for long. And then the other one, the lifetime income investment strategies, that's kind of a little bit new. I mean, there are certain aspects of that were kind of in plans, and certainly in the defined benefit plan world, you didn't need them because annuity is the normal form of payment. Mm-hmm. And so, but yes, no, I mean, and I would also say that even in 401k plans, that some plans have had private equity for quite a while. And it's also the case that usually there are plans who took into or had these other things, again, taking out the commodities and the lifetime income, have had some of these in one form or another, usually in some form of fund to invest in. Now, I would say that was an exception. I saw some article or some reference that maybe less than 1% of defined contribution plans have private equity in them.
Okay.
I did know actually I had an employer that used to allow private equity in their brokerage window until all of a sudden a tax bill came up that somebody created unrelated business taxable income, which threw in everybody into an expensive situation because the person actually retired and took their money and there was the tax bill. And it was,
oh, no. No. Okay. Yeah, I don't like the sound of that. So the novelty that we're seeing here is really on the 401k side. And what do you think is driving this 401k investment revolution? Why are we seeing this shift?
Yeah, I would say two things. One is that in one sense, one could say there's no investment revolution because people have always had the availability to do these things and under ERISA. And you do. You have, that Supreme Court's case dealing with Intel. They did exactly what it's almost like the Department of Labor took the Intel model and plugged it into their regulation. But other firms, and we had a client who really had a lot of that type of approach where they went very diversified, created their own custom target date funds. So in that sense, it wasn't new. Really to me, I think there's a bigger context than all of this, which I think is really important, is that there is, to me, a major shift in the market in that traditionally mutual funds really just dominated the whole 401k market. I mean, it was all mutual funds, really easy. You got an investment manager. Hey, I could pick a mutual fund line up, easy enough to it. Well, there's a shift occurring from mutual funds to collective investment trusts. And I have to admit, I hear this so often, or this kind of line. Oh, we're just shifting from the mutual fund to the collective investment trust. It's going to be the same cast of characters doing the money. It's just a lower fee. We're just lowering the fee, sign here. And that is in one perspective, I understand it. But I mean, I've heard this from CFOs. I've heard it from investment advisors. I've heard it even some attorneys say that. And it's sort of like, no, they're fundamentally different from an ERISA investment standpoint. With mutual funds, when you invest in the mutual fund, the only plan asset is the equity in the mutual fund. It's the whatever certificate, the stock equivalent of the stock certificate. When you invest in a collective investment trust, you are not only, or the underlying assets of the collective investment trust are also plan assets. So not only is your participation interest in the collective investment trust a plan asset, but also the underlying investments in the fund. And you might ask, well, why does that make a difference? Well, that means not only are you making an investment in a collective investment trust, but you're also appointing a fiduciary. You're appointing a trustee. And you say, well, okay, so we're appointing a fiduciary. Well, that means a lot. If you're appointing that fiduciary, you have potential co-fiduciary liability. If those rules are out there. You also, if you appoint a fiduciary, number one rule, I'll put Agnes on the spot. What's the number one rule when you appoint a fiduciary?
You have to monitor that fiduciary.
Exactly, Agnes. Good. And so you have to monitor them. And so, is the monitoring is likely going to be different. For instance, example, proxy voting. With a mutual fund, unless somebody really stuck to some duty of loyalty to kind of pierce everything, you don't really care. You're looking at what are the returns of the mutual fund. You're really not going underneath. Well, collective investment trusts, fiduciaries as part of your investment have a duty to monitor the proxy voting. So what does that mean? Well, to monitor means you really have to inquire about it and get information about it to see what it is. Now let's think, are there other things that could happen with investments in collective investment trusts that are different? Well, yeah, how about prohibited transactions? Employer stock is not an issue if you invest in a mutual fund. Who cares if they invest in you, it doesn't matter. Well, you do matter because if it's plan assets, you're not allowed to invest plan assets, or you can in employer securities only if they're qualifying employer securities and you have all those realm of requirements. Let's take securities lending. If a mutual fund does that, oh, good. Maybe it's more return. If a collective investment trust does it, well, you might want to worry about, are they complying with the securities lending prohibited transaction exemption?
Mm-hmm.
Really big difference.
Yeah.
And Agnes, here's a question. We'll put you on the spot again.
Oh boy.
Mutual funds, can you negotiate those?
I actually don't know.
No, you can't. No,
Okay.
look what you get. Or at least I think so. I shouldn't say that. Maybe
Yeah.
somebody has enough influence to create another mutual fund class. But how about collective investment trust? You know this one.
Yeah, absolutely. Mm-hmm. There's a lot of back and forth that goes into those.
Yes, Agnes and I worked on one of those the other day.
Yeah.
And so there's a possibility of negotiations. And is that important? Yes. Well, for three reasons. One is you just have the ability, but in the collective investment trust, you're actually going to enter into a participation agreement. And that participation agreement has representations.
Yeah.
Well, can you make those representations? And the answer is, well, mutual funds, anybody can invest in a mutual fund, but it isn't the case with collective investment trusts. Like 403B annuities, they're still trying to push through a provision in Congress that allow 403Bs to go into collective investment trusts. PEPs weren't allowed until 3 weeks ago. The SEC came out with some guidance that PEPs they have a non-enforcement policy that PEPs aren't going to violate the rules, that you really can't have KEO accounts and IRAs going into a collective investment trust. Yeah. And so it isn't obvious. And how about, with mutual funds, when you go and buy one of those, do you have to make an indemnity? Are you indemnifying the mutual fund product? No. But you are going to indemnify under the standard participation agreements that you have for a collective investment trust. Are there more problems, or not problems, more considerations? Well, yeah, besides going and trying to get reps that you have, make sure you're complying with the reps that they're asking you for. Yeah. And you're giving the indemnity. Well, the flip side is, well, are there representations as you as a client want? The plan fiduciary. And the plan fiduciary, and the answer is, well, yes. One that it's always good to dwell on is the Department of Labor says with cybersecurity risk that you're supposed to negotiate provisions when you have plan assets. So there we go again. There's another thing you have to think about. Well, are we foregoing a lot of good representations? And then my favorite, the one that's most key, is, and this may come as a surprise to a lot of people. Most collective investment trusts have a provision that says the trustee can basically cease transfers at any time it wants. And so, it's not only, we have liquidity, or kind of liquidity issues in one sense with collective investment trusts, because if you look at that, I always try and negotiate it out, and it always comes out to the same place. If it says, we'll never exercise that because it's disastrous to us. Good. Yeah. Well, if it's not disastrous and you're never going to exercise it, take it out. Oh, no, we can't do that. And
in case of an emergency, that's,
Exactly. In case of emergency, we're going to put this in there. And so, Agnes, what do you think about our participants when they find out that there was an emergency and you've already all of a sudden locked them into a fund that is probably the emergency is that there's been a run on the fund for some reason?
That is not a fun conversation to have. Certainly not. You mean I can't access my own money? Is that what you're telling me?
Exactly. And so maybe you could say, well, it's for the best of everyone. Everybody's in it together. Well, what if somebody negotiated out of that provision? Then it's sort of like getting really nervous, is that somebody will say, wait a minute, somebody else negotiated out of that provision or somehow was able to use some leverage to do that. And you didn't even try, you didn't even negotiate. You didn't even think there was a difference with mutual funds. It has that flavor of difficulty. So to me, that is the investment revolution that's going on, that we're having a major shift where investment advisors, and if you think of it, it plays all the way through the chain. You have advisors who previously could pick mutual funds, but are they going to be or willing to? What are they going to do with collective investment trusts and this whole negotiation issue? I.e., some of them I've seen say they'll take on that responsibility. They say we're going to perform the legal review. Some investment advisor firms will do that. Now, a question is, there's a plan on the plan fiduciary side. Do you want them to be doing that, or even a plan sponsor? Because you just give them blanket authority to negotiate the terms of the agreement. And maybe you want that. And, there's some benefit of that, but, you get nervous. But if you're a small investment advisor just with 401k plans and telling them, are you going to hire an attorney, or are you going to farm it out, or are you going to be able to bid against other ones who do that? And so it's a rub. It's a rub for the the bigger ones. What are we going to do? Are we going to negotiate these agreements, or are we going to pass it along, or what is that interaction going to be? The other component of modern, I have all kinds of talk here. Another part of the modern complexity on this is that we are now getting into pooled funds. And so real life example is a client goes out and it's always you go out with the RFP, and I didn't participate in that. The 321 versus 338. And so this client, and this is another attorney's in office client, comes up and negotiates, and they want the 338 because they want to minimize their liability. So then about I don't know, probably like a month or two into their relationship with the new entity, their investment advisor, it was pretty significant. I mean, it wasn't just a mom and pop. This was real money, real people. And the investment advisor asked them to sign the participation agreement to the collective investment trust. Well, if you read the collective investment trust representations, it says the person signing has thoroughly analyzed and understands that they're making this investment decision. So, in-house attorney, our attorney partner asked me to look at this agreement, and I go through it and I said, "Oh, this is awful. They're shifting all the responsibility back." So we go through. I went through this massive thing and send it back, and to the client. And you never know how that's going to play out, but in this case, the person read it, which is great. And they not only did they read it, they understood, and they quickly understood, this isn't what was promised me. This is not what was promised me. So it was a really long back and forth, because the client kept coming, well, they haven't shifted at all. They're still shifting. And the client, I think, eventually, those moments, what if they don't give it to us? Because it really wasn't just an investment decision any longer. It was whether to terminate who they just took. I think the client was seriously going to get rid of them if they didn't give on the point. It's easy to negotiate. I don't negotiate at all. The client negotiates it because she had fire. She did not like what happened. And so there we go. And so all of that, and there's, when you have these pooled investment plans, and you have this pooling, and you have the 338s where they want to combine, it's a lot more complex. There's fiduciary issues. There's conflict of interest. So the investment revolution is that the whole new collective investment trust is really shifting the level of you have to up your game. I mean, if you're somebody players in it, and these issues, they're there, and so I do have some more comments, but let's move on. I'm sure. I think it's important. It's because it's context. Is that all of what we're going to be talking about plays into that, because collective investment trusts are the main way in which target date funds are now presented to plan fiduciaries. It's the main way that these private equity funds and other things are going to be placed. So all of this, all of these things that they're referring to are really, I think, are aimed at the target date funds. But we'll get to that in a little bit.
Okay. No, that's interesting. So we already have all of this complexity, right, that we're trying to manage and navigate through, and then we're going to throw in like this new type of asset. And to your point, the alternative assets aren't brand new to 401k, but the way that it's been, I guess, introduced and the way that we're looking to incorporate alternative assets has certainly not been done before. And so we get this proposed rule that comes from the Department of Labor, which is a direct response to President Trump's executive order that came out in August, called democratizing access to alternative assets for 401k investors, right? So alternative assets for all. If you have a 401k, you get access to alternative assets is essentially what we're looking at and what we're talking about. And so the Department of Labor and the Securities and Exchange Commission had the task of trying to figure out how to increase access, how to allow this access into the American retirement system by way of employer-sponsored 401k plans. So you touched on this before, just on how alternative assets include private market investments, interest in real estate, digital assets, commodities, lifetime income investment strategies. So, I mean, the rule is pretty broad. Pretty much anything that's not your typical stocks, bonds, cash is effectively an alternative asset under this proposed regulation. And so I guess to curb the unpredictability, the Department of Labor gave us this process-based safe harbor, this asset neutral, also process-based safe harbor. So this was introduced to us in the context of trying to introduce alternative assets to us, but the proposed rule in and of itself, according to the Department of Labor, is asset neutral. So if you are looking to add an investment vehicle into your 401k plan, you should go through this 6-step process that includes evaluating these 6 factors, which include performance, fees, liquidity, valuation, performance benchmark, and complexity. And the idea being that if a plan fiduciary objectively, thoroughly, and analytically considers these 6 factors, then they're presumed to have met the duty of prudence and they're entitled to significant deference, which, like, on the one hand, sounds like more stuff to do. But on the other hand, there's this, what sounds like, or is being presented as, this protection for fiduciaries. So let's just walk through the factors really, really quick. For performance, we want to see fiduciaries evaluating risk-adjusted returns over an appropriate time horizon against anticipated fees and expenses. And then when you consider those fees and expenses, determine that those fees and expenses are appropriate given the expected risk-adjusted returns and other values that the plan may receive, benefits, features, services, where you can arguably state that it's prudent to pay those higher fees in order to get better service. There's a liquidity requirement stating that investment options should have enough liquidity to meet the needs of the participant. So their funds should not be gate kept, as you spoke about earlier. Like there should be able to have some access to those funds. Valuation, that the investment can be timely and accurately valued in accordance with the needs of the plan. So there's a little bit of a trend of you do what is appropriate for your plan. There's a performance benchmark requirement stating that each investment should have a meaningful benchmark to monitor expected returns against. So one type of investment should be monitored against a benchmark that's appropriate for that investment, not necessarily cross-comparing, dipping into different pools. And then to also evaluate the complexity of the investment alternative, which you touched on earlier. There's a lot of layers there. Is it the plan fiduciary that's looking at the agreement under a collective investment trust to do all the negotiating and determine what reps that they want to agree to or not? Is that an extra expense? Do you have to bring in experts that are going to help you to do all of that? How does a plan fiduciary monitor all of that, right? But this is what the DOL has left us with. And again, if you can illustrate that you appropriately considered all of these factors, you fall within the safe harbor and you're entitled to significant deference, which is notably not defined in the text of the regulation, not currently. So there is a footnote that points to the abuse of discretion standard, which I guess alludes to the idea that if you end up in litigation, you can show your 6 factors, and the court is supposed to give you that abuse of discretion standard. But what in practice do you think these 6 factors mean for fiduciaries? Like it sounds nice. And I think my first read of it was, oh, this is just a reiteration of the fact that ERISA is a process statute. Like, we're very focused on the process. But how is this different from what we already knew about ERISA and the process?
Yeah, actually, I had the same, my initial reaction when I read through it was, well, if you do all this, you would have won in the court anyways.
Yeah.
Did you really need it? But what I think where it's going to go from a practical standpoint, and I mean, I've been in meetings where these things are discussed, is that what people end up doing is that when you have a safe harbor, your attorneys will come in and say, well, let's meet the safe harbor. Who doesn't want to meet a safe harbor? But the second part of it is that, well, how do you meet the safe harbor? And usually what people's thought are, well, we'll turn to our investment managers, our investment advisors, and ask, do we meet the safe harbor? And so all of a sudden, I just went through my oh, wait a minute, collective investment trust, that's a lot of complexity. Now we're going to potentially, it's going to be asked. We're going to ask those advisors at some point, if this gets finalized in its current form, et cetera, say, we want safe harbor. Are we safe harbor? And that's going to be a tough question, one of those rubs where, how is it going to play out? Is the advisor saying, no, I can't give you that? And then well, that's not going to suit well in the market. Yeah. On the other hand, if the advisors come through and say, yeah, we'll do that, they're going to be taking on more risk. Are they going to be asking for additional fees to do that? Yeah. I just, and it's already percolating in. It was funny as I was just reviewed a 338 agreement, and there it was, we don't provide, this agreement doesn't cover advice regarding alternative assets. And so they're already cutting back and saying, we're not touching assets. And interesting. And there it is, it's sort of like or at least they're not going to do so without more, we'll see what happens, but they don't want to go there necessarily. And so, but I think a couple of things is that, so sort of in my kind of analysis of saying, we were in a place with collective investment trust being more and more so becoming the prime investment vehicle for 401k plans as compared to the mutual funds. And all of a sudden now we're really upping the ante of, how many investment advisors, again, know about commodities, know about any of these things, commodities, private equity, because they are different. Yeah. And so it is upping the ante, or at least in my I put that out there in a sense. But yeah, to your direct question, I think for the plan fiduciaries, I should also say, I've been in a few meetings, and I think this is, let me step back and say, I think one of the questions sometimes people ask, well, what's driving this, all of this? Yeah. And we know, Agnes clearly indicated, well, the main driver that we got this is clearly that we had an executive order that says we need to democratize assets. And so the question was, well, who's driving this, or where is it driving from? Is it the participants? I never heard of plan fiduciaries who make up the investment lineup say, boy, our participants are asking for it. I don't know if you've ever heard any feedback in that sense.
Never.
And right before our call, I guess we were talking generational. I said, I don't really think, I don't see that big drive to demand alternative investments. And Agnes says, well, I don't think so either. All of
Yep.
us know we're not so sure about that. So, again, isolated examples, but neither of us thought it was, just kind of a general proposition that says, oh, I don't think anybody, I should say, at the associates meeting, I'm sure they're not demanding, Thompson alternative
That is
assets.
least of our problems.
You
Yeah.
don't give me that alternative assets in my 401k. No, it doesn't work that way.
Yeah.
But the second group then is, well, how about our plan fiduciaries who make up the investment lineup? No. And I've been in meetings and all of them, it's kind of the big yawn in a sense of, and really some of the advice goes, and we could talk and we'll get in more detail. This sort of like, it doesn't require you to invest in alternative assets. And most of say, if it fits, maybe down the road or something. But it's at least for a general entity that really, they're not, I don't think they're the driver at all.
Yeah.
I think, or at least a lot of people said, there's another group is that, and it wasn't the attorneys. I mean, we're not saying, this is a great idea. It was really, if you look at the history, there are, and it's I saw somebody quoting or taking a part in there, is that there's $2 trillion in target date funds and 401k plans. And there was some kind of projection. Again, this is secondhand. I didn't go back to verify it. That said, if just a certain percentage of those target date funds invest, maybe like 4% of it a year gets into alternative investments, that's $200 billion.
Yeah.
And so one driver is, I think, that's where the money is. You want to get into that. If you're a big outfit in the private equity market, you definitely, this is great. And now I will say is that I think they do believe in their product. There's those products. And it's also, I'll step back for a big picture thing. I like big pictures. Is that one of the things is defined benefit plans have historically outperformed DC plans.
Yeah.
And the reason is that defined benefit plans have a little bit more flexibility. You can invest in private equity in a defined benefit plan rather easily because, not totally easily, but you lock up a small percentage of your assets for 10 years. It doesn't matter. You have plenty of assets, and it's usually a niche. It's the same thing they're talking about these target date funds. Very easily done. And historically, you get better returns because in one, you're getting this liquidity premium. The 401k fund has always had this liquidity issue. And so because of that, it's a little bit more difficult to do it in the 401k plans.
Yeah.
And so one of the things that, a lot of the proposals that are coming out are trying to create designs to help, address a lot of the issues that have been present with with private equity in the 401k plans. And then liquidity is a big one because we know that right now the structure is that, people like the daily trading. And so it's hard to have a liquid investment. And again, I should say, I don't think there's any thought that you're going to have a private equity fund as things are, at least under this rule in general, as a standalone designated investment fund, because there's no way you can have all the money go in and have daily transactions from that fund.
Yeah.
So really all of this is describing what would you do in a target date fund. And as I said, we had a client that did have real estate, did have commodity, or did the infrastructure, had those as components in a target date fund, just because they did a custom fund. And they were saying the exact same thing, is that we think our glide path is better, and it helps in both up markets and down markets. So I think in that context, and let me go back to it, is that was where to me is the drivers of it. And so if that was where the drivers were, then, is things going to change, at least as far as the investments? But I'll pause there and say, in reaction to that, Agnes.
So then what factors, I guess beyond, the safe harbor factors that the Department of Labor has given us in this proposed rule, if a plan fiduciary is looking to incorporate alternative assets to their lineup, given maybe there's a little bit of a gap between the intention behind introducing the lineup and the fiduciary's ability to actually implement that, what risks are involved there? What factors should they be considering?
Yeah, I would say, well, actually, this is kind of forwarding a little bit, is that the guidance has all these examples about this is my opinion, is that in some ways I get it that this is asset neutral in the safe harbor. But if you look at the examples, all of the examples are geared toward alternative investments, or not all, but actually the ones that are favorable. And everything, how it's discussed in there, is very here's a roadmap for alternative investments. So plan fiduciaries, they say, and really where you're looking at it, you could take each of those prongs that we were just discussing and say, how does that apply? And there's an example then, how can you satisfy those? So if I was, again, on the plan fiduciary side, one of the key things, and again, this is on the real experience, is that on the private equity that I do on the defined benefit side for this one client, is that they have a pretty notable big advisor, good name brand advisor, providing them investment advice, except for their private equity. They have a special person providing advice on private equity because it is different. And so one of the questions is, and this is the difficult part, is when you as a plan fiduciary, you're going to look at things, how far do you go, in the sense is that you're saying, okay, we have a target date fund. Can you just say, all right, it has a 10% sleeve in private equity. How much, or should we look into what they're doing? And this is an issue that I wrestle with on, again, this whole issue of just did this 338. Do I review, or do I well, I don't think the client's going to pay me to review what they're already doing, negotiating they agreed to negotiate and do the legal review on whatever investments, or whatever things, collective investment trusts and other documents that they invest in. So, but there is almost like a duty. Do you need to peek under the hood? That's standard. If our ERISA litigators will always say that you can't blindly accept other people's advice. Right. You have to kick the tires. So the question is, do your regular advisors, are they able to kick the tires? In a sense of going through, and do you need to go that deep? I don't know the answer to that yet. It's going to play out. Maybe you can just, how much, clearly people look at glide path. Clearly people look at kind of how those maybe segments are performing and are just going to feel of it. But is this more of a risk that you would be concerned about? How locked up are the funds? How much liquidity is there? And one of the things, this is, we talk about this being asset neutral, but one of the things is that the examples really help you out. They say, well, I keep using the target date fund. The target date fund investment manager can do a liquidity study for you. And if they do this liquidity study and it meets certain requirements, that means that you satisfy the safe harbor provision for liquidity, which is kind of funny to me, is that if you have a provision in an example that says you satisfy the safe harbor, one would view that, well, that is part of the safe harbor, which means we have a provision that is there. But it gives you, one of the big things is this whole liquidity thing. And the example says, if you do this, you're going to satisfy that liquidity issue. And maybe that's going to give you comfort on that. But also on all the other factors, there's the flavor of them says, if you do these things, this is going to happen. And the question is, you want to make sure that each of those 6 factors that you look at, that the fund, target date fund that would have this sleeve of alternative assets, whether or not it meets those requirements.
Yeah. And okay, so let's dig into that a little bit, because part of the reason why you want to meet the safe harbor is this theoretical protection from litigation, right? So we know that ERISA litigation is like crazy, constant. The number of cases is like doubling itself over time. And so part of the intention of this safe harbor was not just to introduce alternative assets into 401k, but also to, curb, tone down, provide some protection from some of this extreme amounts of ERISA litigation. There's this tension, it seems, though, between the additional requirements that come with adding such a complex vehicle like an alternative asset, and then having the safe harbor supposedly in your back pocket. And I know we've had conversations about how helpful it's actually going to be in practice. Can you talk a little bit about that?
Yeah, no, I totally concur. I always thought these two things about being asset neutral and then having specific alternative asset examples and everything else. And there are comments, I will say I have not read all 48,000 comments on these regulations. But
shocked, Brian, I'm shocked.
But the reality is, I pick up things, I'm looking at it. And some of them say, oh, this alternative asset, let me phrase it this way, it's kind of quirky, is that even with the big supporters of these regulations, they all kind of say, yeah, the safe harbor is great, but man, maybe you need to make sure that it's not so, sounds like you're really forcing us to do these, that these are only illustrations, that these aren't mandates in these examples. Yeah. And because I think their concern is if you look at each and every one of the examples, and let me give an example of this. Oh, actually, I'm segueing away from the litigation aspect, but let me go back to your litigation, but we can go back to that. So on the litigation, it's important to say, okay, we have a safe harbor, and in litigation, there's 3 stages of litigation. The first stage is they call the motion to dismiss on the pleadings. This means that the plaintiffs, by participants, file a complaint, and basically the plan fiduciaries can file a motion to say you haven't stated whatever you stated in your complaint doesn't satisfy the requirements to state a valid claim. That process, and I'll just throw numbers out, is that it may cost $200,000 to go through that whole process before again, maybe I'll use 100,000. That'll cost 100,000, but it's going to cost money for somebody to go through that process of attorneys to evaluate the complaint and do it. But almost all fiduciaries will say, yeah, let's do it. They're not going to settle without doing that filing of the complaint.
Right.
The second stage in it is that if you go beyond it and the court says, no, we're not going to dismiss on the pleadings, we're going to go to the next stage. And the next stage is discovery. And that's costly because now they're wanting to talk to your investment committee members. They want to talk to whoever's making these decisions. They want to look at all your documents, and then they're requesting documents, and maybe all of a sudden you're getting experts. And so the cost of that second stage may be, maybe the first stage was $200,000, the second stage may be $800,000. Yeah. And so we really are saying, do we, as whoever's paying for it, do we want to spend the money to, $800,000 through this discovery and all this process and have that kind of interruption in everybody's lives to focus on this litigation? And if you say yes, well, good, but then you get to the motion to dismiss, or not, the summary judgment. In summary judgment, based on all of the facts that you looked at discovery, they say, once again, based on the record, you haven't stated a claim, or there's really not a claim. I mean, you get summary judgment based on these facts, you lose. Yeah. And at that stage, you may get it, you may not. And then the last stage, which costs us another million, is the litigation, where you go to trial. You have people, experts in things. And so
Yeah.
all along those stages, the most critical one that is really that first one, because if you can get out early, that's great.
Mm-hmm.
The courts have really wrestled with this, and is because ERISA is all about process. Participants have no access to any of the process information.
Yeah.
What they do have access to is like from Form 5500s, what is your fee? And
Yeah.
benchmark comparisons. Mm-hmm. And so the courts, sometimes you win and sometimes you lose.
Yeah.
It's, and so, well, of course, the plaintiffs, if it's 50-50, and if they get buyouts in the court that they're in, all of a sudden now we're in the second stage, and a lot of people just settle for $1 million here. And,
Right.
that's that's probably under their policies, or they can afford it, because, well, if we settle for $1 million, well, we could have continued for 800,000, but that was no guarantee we're going to win at that stage.
Right. Exactly.
And another 800,000, and we could have settled for $1 million. Well,
Yeah.
it makes perfect sense we're going to settle for $1 million. But that incentivizes the plaintiffs, because, hey, I could go in, file this cookie cutter complaint.
Yeah.
And it goes in there, and I have a 50-50 chance to get back past the first stage, and there I go.
Yeah.
Well, okay, so that's the big picture context for the litigation. Well, if you look at this, everything in the safe harbor says upon a thorough review of this, and upon doing this, well, that's all factual. There's nothing on the complaint, and so I read, it's always good. I this is all confirmed with the litigators, but I had the same reaction, is that, hey, this is going to help at that first stage. And maybe it will give just a little bit of help at the second stage. But it really isn't likely to change that altogether. It's, it's probably the, influence of what the court you got in, the sort of some judges favor a little bit, some others is probably a bigger factor, but maybe a little bit. So it really, and also our initial reaction, well, if you do all these great things, you thoroughly, and I will say, let me segue, is that it really, if from a litigation standpoint, in one way, from a litigation standpoint, it isn't perceived to give a huge value. Now, notwithstanding that, people are going to go for it. Whatever. But it's also, I would phrase this. Yeah, I would say that is it. Now, let me be clear in the sense of, because we're, the Department of Labor, I mean, I don't think anybody disagrees where Agnes said is that litigation is huge right now. Mm-hmm. And from a big picture, this has a real flavor to it, in a sense of almost like frustration, of saying, courts, you need to decide, and you need to do something about this. And the Supreme Court has a case in front of it. And the Department of Labor has done an amazing job for the first time, I think, ever, files amicus briefs on behalf of the employers and plan fiduciaries, the sponsors and fiduciaries. Actually, it's really the fiduciaries, because they're the ones who not. And so the plan fiduciaries, I mean, I thought it was a brilliant, in the annuitization cases where people were being sued. There's a standing issue, and one of the things they said, well, if you annuitize somebody's benefit, you're going to lose your PBGC protection. And the Department of Labor comes in and says, nobody's ever lost a dime under state insurance law insurance program. We have lost hundreds and hundreds of millions under the PBGC program. How can you say there's a vital interest for a participant to stay in the 401k, in a pension plan and annuitize? So they've done incredibly good work. Mm-hmm. And in a sense of big picture, optically, it feels good. And everybody, I think, loves it. I don't think anybody was clamoring for it, because I don't think people would have stopped. Well, let me phrase this. There's also an issue, is that when it comes to all of these issues, i.e. motions to dismiss, summary judgment, what you need and what you don't, those are inherently within the judiciary. This is what they do. I mean, this is there. And, we had the Dudenhofer case regarding stock drop suits where the Supreme Court says ERISA has no presumption of prudence. Boy, this sure sounds like a presumption of prudence. This certainly sounds like this huge deference. It's one thing to give deference on claims. Boy, fiduciary, but claims, you don't go through a claims process for free, except one circuit, and they're about to change their mind. But you don't go through a claims process for investments. You can go fiduciary breaches directly into court. So, but big picture, optically, kind of politically, trying to push the court to do things. I think that's why everybody's, oh yeah, that's a great idea, and it's also why everybody feel you go into meetings with clients and they, oh yeah, no, they're really interested. Oh, that safe harbor sounds good. When that gets finalized, yeah, well, and the idea, and they all kind of nod their head. Yeah, that should seem to be something that our investment advisor can do for us.
Yeah.
And so, so on the ERISA litigation side, it's I'm not sure. I will say also then on the flip side of this is that even you go into the meetings, they're all interested in the safe harbor side. They're actually, I said it before, it's kind of the big yawn. I don't know about alternative investments for our 401k plan. It's really a lot of skepticism. But again, I'm not sure in the big picture from a big picture, there is a certain truth to the notion that private equity in defined benefit plans does generally provide greater returns, or at least that's historically what it is. Although certain things change, and I actually was reading an article the other day that says that it's really for like the large funds. They said it's no different than the public equity, but they basically leverage their investments, and so get the benefit. But so even on that side, I think in the past, there was some of this back and forth where there was a Department of Labor opinion letter saying, oh yeah, you can, there's nothing that prevents private equity going in, sort of favoring this. This was in the first Trump administration, and then the Biden administration came back and said, be careful. You have to know what you're doing. And basically, yeah, sure, people who've been doing it in the private equity and the defined benefit side, yeah, you know what you're doing. Yeah, you could probably easily start thinking about doing this. But if you're, again, a 401k plan that all of you've ever invested in is a mutual fund, and your advisor is just again, it's like a financial plan or level advice. You have the whole spectrum. They're perfectly good, but do they have an economist on staff, or do they have do they have something? Do they have attorneys on staff? That some do. No. And so, so I'm on the litigation. It feels good. Again, these are all personal comments, not to be attributed to any client, anything.
Right, of course.
Some of these comments are, I'm not the only one. I pick it up on some of the highlights of, the commentary or highlights of what people are saying. And this actually, we even put in our kind of our ERISA blog article that Agnes and I wrote, is that, so we're actually on that one, we're safe. It's public. We put it out there, and that got vetted. But in any event, that's there. Agnes, do you think? I'm just we could get into more detail on sort of each of these factors and sort of how they really, at least in some ways, favor. I mean, is that, or is there something else that you were thinking we should cover?
Yeah, no, I wanted to go back to that because you started to raise it earlier, and I wanted to make sure that we came back around to it. We've got just a few minutes left. So if you can quickly just touch on. Great. I know. Yeah, the time flew.
Agnes was worried that we wouldn't fill up the full hour.
Oh, no. There's plenty here.
Yes. Okay, so let me, and actually one of the things there's a flavor to this is in creating this roadmap for alternative investments, there's a real, I read this and I said, are they creating a roadmap for the plaintiff's attorneys? because that's the flip side. If you have a safe harbor and everybody starts using the safe harbor,
Yep.
well, why aren't you doing the safe harbor? And again, they have answers, but there's a lot of unique things in here, like it's just kind of a flavor. Now, one of the things, this regulation seems to have everything and everywhere. I mean, it says one thing, and it's kind of funny, and then it says something else. It says, like, under the duty to act prudently, they introduced this new language: maximize risk-adjusted returns. Brand new language. Yes. There used to be pecuniary factors, risk and return factors. But boy, maximize risk-adjusted returns sounds so quantitative, and it sounds like why it's there is if you flip to. It's also one of the factors. It's strange. It's one of the things that duty to act prudently in its own little section. But then it says you have to look at other factors. And so it's always a factor. And then how do those other factors kind of override that factor? It doesn't really flow. It isn't. It's like if they were trying to combine two concepts: a safe harbor that's neutral and the alternative assets. But in doing that, if you look at the example, well, what does it mean? Well, in the target date fund, they give the example. They say over a 10-year span. I don't know who measures things over 10 years, but again, if the example favors alternative assets, or it could be viewed that way, although it's not a bad way. Again, we had that client who created this wonderful, target date fund. It says over time, once you get into a bear market, we're going to perform better than other funds, funds in the market who have a different glide path or a different asset mix. But if you look at it, they said, well, you can always hire an investment manager. If you don't understand it, ask somebody. Or go. But what if, I'll give you an example. I'm very fortunate. I think the world of my wife, and she is incredible when it comes, she understands poetry. Anybody who understands poetry, music, beauty, I just think that's incredible. I'm more on the math side, the economic side. My wife, I don't care how long, she'll never get math. It's just people are different. But in here is that I think there's some people, you'll never be able to get to the level of, like, will I understand commodities? Will I understand the nuances of private equity? So I think there's somebody who's a small enough plan they might not even have sufficient knowledge to they understand mutual funds. They might get the collective investment trust stuff after a little bit if somebody gives it. But boy, I don't know if they really feel comfortable to understand alternative assets at all. And so the idea is that, and I don't think they maybe even know enough to hire the right person to hire to do the alternative investment assets.
That's a good point. They need
this happens in 338s. Somebody hires the 338 and then it downsizes internally, and then they don't have the expertise to monitor the 338. So they have to go and hire somebody to help monitor the 338. And it happens in practice. But so it's sort of like, but what if you just don't understand? And then the other, but all of them, the maximize risk adjusted, that sounds like, where that was is they say, do stochastic, best modeling, do economic modeling. If you do economic modeling, well, it's not, usually if you have another factor that acts differently than an existing factor, like private equity would give you better returns in certain markets and things, it's almost it will play out pretty much that it's going to be under these economic modelings, the best grouping of assets, it's always going to win. So what does that do if you really didn't want to run those in there? Or if you say maximize, can you have can an entity offer both? Can can a provider offer with and without?
This is stressing me out because there's that. No, I'm saying this is stressing me out because there's also ERISA's duty to diversify your funds and your investments. So if we're saying that we're only going to pursue maximize, we're maximizing for what market? And how do we diversify if we're going to focus on maximizing when the market shifts? And I don't know, that sounds like trouble.
Exactly. If maximize really means it. I mean, can you do an active fund and a passive fund in the sense it's the same market? I have it open here because I took it out again. I read it, I don't understand it. I mean, I understand in big picture of saying, hey, maximize risk-adjusted return the same as using pecuniary factor or risk and adjusted. But if you kind of get the feel of it is, oh, we want some economic modeling. And again, who's going to do the economic modeling? I mean, the top people, I mean, the top firms can. Do they want to? Are they going to charge you? So there's a real, I'm not sure what it means, but it certainly means, but again, it flavors into, well, currently economic modeling, I think is going to help push alternative assets in. And again, that's not a bad idea. It isn't necessarily, I'm not saying it's good or bad. I'm just saying it's different. Actually, a segue. Actually, it's interesting is that I always think that what they should have done, it's always easy. And two things, this is complex. There's no, my heart's out to, the people at the DOL who tried to come up with it, balance these things. I think they did an incredible job for what they're doing. Incredible job for what I feel is kind of an impossible task. Actually, it would have been interesting if they did the flip direction. And they didn't go this way, but I was curious. Way back at one time before the 404C regs came out, people used to have like stable value funds where when you invested in it, you locked in for 5 years. It would seem to have been interesting, instead of trying to make it something look liquid, is to flip it and change the 404C rules and said you're allowed to get 404C protection for a participant who would lock in. And it's easily sellable as saying, hey, you're 25, you put your money in this, hopefully you have enough saved that you don't need a withdrawal, or maybe you take a loan. But in the meantime, we're going to allow you to invest, and you agree to lock in for 5 years or 10 years. I don't know. I just put that out there, is that there may have been another way to address this issue, but they've gone in the other direction of trying to fit the private equity into the 401k. Into the 401k, daily trading, which is just the norm. I mean, that's everybody. Again, I don't even know if everybody wants it. I mean, the reason the target date funds are growing so much is because everybody defaults into them. And it's just makes, I'll just default into the target date fund. And actually, I think in some ways, I hope they do make it through. I mean, in some ways, because I think in the right scenarios and with the right additions, that if they can work through the issues, that it could be valuable. But I don't know if it's going to happen overnight. I'm not sure. I'm not seeing
Certainly it. Not overnight.
But maybe it serves a purpose, if the purpose is to create enough energy that at least there are providers going out there. They're talking about this. They're talking about introducing in 2027 target date funds with sleeves. And so maybe if these come out, it will be the movement. Give enough impetus to move the market so that people will get comfortable with it. And so in the long run, and again, I don't know. It's just like any other investment. It's riskier, but again, if it's built into it, it may prevail, and it may actually give better returns. Or you listen, other people may not. It's private credit. It's going to shut down.
Well, we are over time. So I'm going to go ahead and point out, like, the DOL has gone through their comment period. So maybe somebody somewhere in there gave the same suggestion, and maybe they'll take it. Who knows? But the regulation as it stands is still proposed. The DOL may make whatever changes they'll make before they issue a final rule. And then I'm sure we'll have something to say about it at that point. And so this all concludes today's coffee chat session. Thank you so much, Brian, for sharing your insights. I really, really appreciate you being here. On behalf of Thompson Hine, thank all of you for joining us. We hope you found that this discussion was informative and that you'll continue to join us for future sessions in the series, like whatever update, whenever we actually find out what the final rule is. Keep your eye on your inbox for upcoming programs. If you have any follow-up questions that you would like to ask, please feel free to reach out to one of us directly. We've also published a blog post on this topic. So if you would like to see our thoughts on this memorialized, feel free to take a look at arissalitigation.com. And thanks again for attending. Enjoy your day.